Welcome to today's program, 2021 Trade Secrets and Non-Competes Year in Review. Copies of the slides, a link to the recording, and the CLE verification form will be emailed to you in the days following the webinar. During the program, a CLE code will be read aloud, and you will be required to include this code on the CLE form. Throughout the webinar, please feel free to type your questions into the Q&A box on your screen. Now, I'd like to turn it over to Michael Wexler.
Good afternoon, good morning, depending on where you are. Welcome to our webinar to recap the highlights of 2021. You will hear today from my colleague, James Yu, who is a senior counsel in our New York office. You will hear from my colleague, Robert Milligan, who is one of my colleagues in our Los Angeles office. And you'll hear from myself regarding a number of topics. And we'll go over briefly in the next slide with regard to the agenda. Next slide, Kelly. There we go. As you'll see, we're going to first talk about restrictive covenant legislation and give you an update with regard to what's going on in a number of states with regard to legislation that directly affects non-competes and also has obviously additional effects with regard to trade secrets. We'll go over some of the legislative and regulatory efforts that are going on nationally at the federal level and amongst the Biden administration in this same topical area. We'll discuss some restrictive covenant cases of note from 2021, which may have an impact on decisions that you are making with regard to your businesses and clients. We'll talk about the Defense Trade Secrets Act and give you a recap as to what's been going on with that over the last 5 years or so since its enactment. We'll also then talk about some of the 2021 significant trade secret cases and related computer fraud cases. And then finally, some practical considerations as you draft and update agreements based upon some of the things that we may tell you about today and how you use these policies to protect your trade secrets and other business assets. So we're going to dive right in here. Next slide, please. And slide after that. So what's going on now essentially is there are a number of states, there's approximately 20 right now or so, that have enacted various statutes that affect non-compete agreements. These statutes, they basically take their appearance in a number of ways. One way is they have what's been termed in some states as low-wage earner statutes, which basically say that certain levels of employment are not subject to non-compete agreements. So for example, there may be a dollar threshold, and under a dollar threshold, you can't use a non-compete with that particular employee, and over a certain threshold, you can use a non-compete. There are, in 2021, about 70 states that have various bills in different forms related to this issue. And there have been significant changes over the past couple of years with regard to non-compete law, state by state, and certain efforts at the federal level, which we'll tell you about, that have posed restrictions on what can be done with non-competes depending on the state. And we'll run through some of the significant changes in that area. Also, we'll discuss with you the federal focus recently and comments coming from President Biden and his administration, as well as other areas of federal government with regard to a focus on non-competes. And of course, that brings up a number of issues, what I guess I would call federalism. Who controls the area? Is it an issue that's left to the states? Is it an issue that the federal government can legislate or control through, through, for example, the FTC, and control over many states? And we'll talk a little bit about some of that as well. And we'll also get into and discuss with you and look at some of these issues, because these new statutes provide all kinds of challenges with regard to the choice of law and venue that you use in agreements. There are statutes that affect fee shifting, and if there's an action that's brought regarding a non-compete situation and how fees are handled with regard to if someone is successful or not successful with regard to a claim that may be brought. One thing that becomes very evident with the changing landscape with different states enacting different statutes is that there is no one-size-fits-all approach. And that's important because as some of you know, and maybe you've had this interaction with your own business or with your clients, client comes to you and says, hey, I'd like to have one agreement for all of our employees, and yeah, we have employees in 30 different states. Can you have an agreement that one size fits all? The short answer is it's difficult to have an agreement of one size fits all. There are ways that can be managed. There are ways that you can have an agreement that has certain language that's applicable in some states and not in others. There are ways in certain states where you can use a choice of law or venue provision to take some of those and take those situations and combine them into one state because you're choosing a law or a venue. And we even have new statutes in Colorado. We'll discuss that. In Colorado, that as of March 1st, there is criminalization, an actual criminal statute if someone tries to enforce a non-compete agreement in certain circumstances. So we're going to get into a number of these issues with you. Next slide, please. As we just talked about a second ago, as of March 1st in Colorado, there actually is a criminal statute that constitutes a Class 2 misdemeanor, a penalty up to $750 fine, or 120 days in imprisonment, yes, imprisonment, if you violate the statute that basically says restricted covenants are considered void unless they fall into a few topical areas. Those topical areas in Colorado include sale of a business, which, for example, in California, there's a 16,600 statute in the labor code that says non-compete agreements with regard to employees are not proper in many circumstances, but one of the circumstances that is allowed in is a sale of a business. Here, the Colorado statute does have a safe harbor. You don't violate this criminal statute if you have a covenant that is pursuant to the sale of a business. There are many states, including California and others, and Colorado here, where if a non-compete or covenant is used for the protection of trade secrets, that's a safe harbor in this situation from a criminal statute. You'll also see that this criminal statute provides for the recovery of expenses that are incurred in educating and training employees who are employed for less than 2 years. The 2 years, for example, there are statutes, for example, in Illinois that say that, and this is a fairly new thing, that a non-compete agreement is not enforceable until 2 years have passed, unless, of course, there's other consideration. And that's a new, I'll call it a new statute, a new issue that has been developing over the past couple of years with some case law and now statute that addresses that. But here in Colorado, it's a crime if you don't fall into these safe harbors. And then, of course, you can have covenants for executive and management personnel and officers that are used to protect, for example, trade secrets and that sort of thing. So it's an important item to note in Colorado. Now, is the district attorney going to be running around enforcing this against people right away? Time will tell. We'll have to see. Obviously, there are magnitudes of criminal offenses in every state. And is this something that the district attorney's office is going to jump on? We'll have to see what happens. But also, it's important to note that under this Colorado statute, it's unlawful to use force, threats, or other means to prevent any person from engaging in any lawful occupation. And that's what this statute is focused on. Next slide, please. We'll talk about Illinois, which we just briefly discussed a moment ago. In Illinois, effective January 1st, 2022, there are earning thresholds for the applicability of restrictive covenants. As I mentioned earlier, some of these low-wage worker statutes is what they're generally referred to. In Illinois, you can see a graduated scale as to the applicability of non-competes and what that dollar threshold is for a non-compete. And you'll see it's in 2022, $75,000, and it continues to ramp up from there through 2037. And so below those amounts, you are not permitted to use a non-compete with those types of employees. And then you can have non-solicits. And non-solicits, there's obviously employee non-solicits and there's customer non-solicits. And there's a threshold for that as well in Illinois on this graduated scale, as you can see in front of you. And of course, when we talk about earnings, we're talking about a combination of salary, bonuses, commissions, and any amounts that are electively deferred by the employee, such as a contribution about 401k, in order to determine those thresholds. The reason this is in place, the 5-field rule, as I mentioned earlier, The 5-field rule was case law that came about a few years ago in Illinois that basically said there had to be 2 years of employment after someone signed an agreement before a post-employment covenant was enforceable, or other consideration needed to be given. And this is somewhat of a codification of that situation. Next slide, please. Also in Illinois and other states, I could point out, I believe Alabama, for example, and other states, there's a notice period now. If you want to use a covenant with employees, you need to provide that covenant to the employee at least 14 days prior to the employment commencing. But of course, it's waivable, meaning that you could have in an agreement that the person waives the fact that they didn't get it 14 days in advance. They're okay with that, and you can, of course, waive that. And in Illinois, it's also being required that employees should be notified of their right to seek legal counsel to speak to about agreements that they're asked to sign with employment. Next slide, please. Also in Illinois, a new statute is a fee shifting statute, which entitles employees to recover their fees and expenses. And reformation or blue penciling, that was something that through case law in many states and sometimes in statute, if there's an overbroad covenant, a covenant can be reformed or can be blue penciled by a judge to make it more reasonable potentially. In the new Illinois law, it somewhat discourages reformation, and they use the term extensive reformation. So some case law talks about, around the country, talks about writing a new agreement, and this is some of the codification of that concept that basically courts are loath to rewrite an agreement, meaning to extensively reform it. But it's one thing, for example, if you have restriction for 5 years and a judge says, no, I think it should be 1 year, that's a fairly reasonable, a reasonable form of modifying an agreement, as opposed to writing something completely different and putting in all kinds of new language into a covenant to make it enforceable. Some of the items that are supposed to be considered with regard to reform are the fairness of the restraints as they're originally drafted, and then does the original draft of any such agreement reflect a good faith effort to protect legitimate business interests, as opposed to something that's just meant to stifle competition or be punitive. Next slide, please. Let's talk about Nevada. Nevada, as of 2021, effective towards the end of the year, they also have a low-wage statute, similar to some of the other states that we briefly mentioned, Illinois, Washington State, New Hampshire, Maryland, Virginia, et cetera. Basically, as we mentioned earlier, it means that a non-compete is unenforceable against certain employees below a threshold of earnings, as we discussed a little more in detail just a moment ago in Illinois. And of course, employers cannot enforce a customer non-solicit that prohibits even acceptance of business. So for example, someone doesn't solicit business, but a customer comes to someone even though they've left their prior employer and offers them business. Employers can't, in Nevada, enforce a customer non-solicit if it prohibits them from accepting business, meaning they didn't solicit it, but it came to them. There's also in Nevada, pursuant to statute, fee shifting, that an employer can be liable for fees and costs if a restrictive covenant is essentially overbroad, if it violates the statute or is found to be overbroad. And it also, under the statute, applies to declaratory judgment suits. So, for example, if an employee brings an action and they say this agreement's unenforceable and they win, then in that situation there can be fee shifting. The employee's fees can be paid for. Different than, for example, if an employer brought an action, lost the action, there would be the possibility of fees in an action that's brought, but an employee can also potentially get fee shifting with regard to declaratory judgment action, which usually goes to the enforceability of a covenant. Next slide, please. Let's jump on Oregon. Next slide, thank you. Oregon's been very active in this area. Oregon has had a number of changes to their statutes and has the same sort of low wage earners thresholds as a number of other states. Oregon has been very active with a number of statutes, with most recent one being in May of 2021 that affects the non-compete space, and they have now gone to a 12-month maximum with regard to a non-compete, which is even lower than a prior restriction, which was 18 months. They've also changed their compensation threshold with regard to non-competes being applicable. So if your gross annual salary or commissions don't exceed $100,500, in that situation, non-compete may not be enforceable against an individual because they earn under the threshold. And then finally, the Oregon statute also basically voids an agreement, not just voidable, meaning that someone can, an employee can say, I want to void this, but it's actually considered void if an agreement is not compliant with Oregon statutes. Next slide, please. Washington, D.C., one of the more interesting changes in 2021, it generally, they have a proposition which I don't believe it's actually been implemented yet, but the statute that apparently may be implemented, it's unclear exactly, will basically say you can't have non-competes for employees that work in D.C. And the exceptions to that are that it's that it's not applicable to government, to federal government, to D.C. federal government as employers or federal employers, and it's not applicable to certain categories of folks. And I find this the most interesting. It's not applicable to volunteers in education, charitable, religious, or nonprofit organizations, which I suppose makes sense. Well, I suppose may not make sense, actually. It's just the opposite. But it's not applicable to lay members who are appointed in office in religious organizations. It's not applicable to casual babysitters. So literally, you could have someone who works in an office and they can have a non-compete, but you can have a non-compete for casual babysitters. It makes no sense why casual babysitters have, I suppose, a great lobby out there that they should they should have non-compete agreements. It's kind of crazy. And then licensed physicians involved in delivering medical services who earn $250,000 or more. It also has anti-moonlighting provisions, and as we note here, it's in many respects it may be stricter than California in that they just outright say you can't have these things except for a couple of these areas which don't make quite sense to some of us, but who knows. Next slide, please. Also, in the statute, there's the anti-retaliation provisions. There's a notice requirement, like many places, that you have to give an employee, notice to agree to a non-compete, and give them, the language and the act and the ban on non-competes. And the notice, has to be, within 90 days of the effective date and 7 days, within 7 days of a new hire, and upon an employee's request within 14 days. Next slide, please. Also, the statute is fairly extensive in that it goes into liability and provides a private right of action and has specified penalties as well, recoveries as well as fines. The issue which I mentioned at the start of this, it's not clear when it's supposed to go into effect. It was supposed to go into effect in the fall. It was pushed back. They're making amendments supposedly, and we'll see when that gets enacted. Next slide, please. 2022, we can expect to see probably more of these statutes. There's several bills in the works in New York along all these different lines, notice provisions, low wage, earner thresholds, those sorts of things. Wyoming, they're considering legislation that may be a full ban on non-competes. New Jersey has a number of bills that go towards how you can enact a non-compete, for example, and if you'd have to pay a salary or pay garden leave. There's other places like Massachusetts and other places have statutes that talk about payment during non-compete periods. And there's other legislation pending, additional legislation in Illinois, Massachusetts, Ohio, Pennsylvania, South Carolina, and Vermont. If you want to keep up on these things, one of the best places you can look is at tradesecretslaw.com, which is our blog that has, we stay up to date on these things, and we, as soon as we hear about new things, someone will write on it and we'll put it in our blog. And it's a good place. It's searchable. you can get a feed from it and stay up to date on what's going on. The next slide. James, I think this is your section, please.
Thanks, Michael, and hello, everyone. I'm going to be covering recent proposed federal legislation and initiatives that are aimed at addressing non-compete covenants. There's been a lot of noise about wanting a uniform treatment of non-compete covenants nationally. You heard some of that from Mike. And in recent years, there's been an increased effort at the federal level to enact legislation superseding state non-compete laws to achieve that uniformity. And as you also heard from Mike, we're seeing a lot of activity at the state court level legislating against the use of non-compete covenants. And similarly, at the federal level, all of the latest proposed legislations are aimed at either curtailing the use of non-compete covenants or even prohibiting them entirely. So the trend has definitely been pro-employee, but as of right now, it doesn't seem like any of the bills or the proposed bills have much traction. But let's take a look at a couple of them quickly. So next slide. So the first one is the Workforce Mobility Act. It's a bipartisan bill introduced mostly by Democrats in February of last year. Next slide. So the aims of this bill are extreme. It essentially would prohibit the use of non-competes entirely, except in the context of the sale or dissolution of a business. And I'm going to actually skip through the particulars of the bill because the reality from what we can tell is that this bill is likely to fail. It simply goes too far. Next slide. If passed, it would literally cause a seismic shift in the landscape of non-competes. Like I said, it's going to essentially ban non-competes. And so because it's pretty extreme, we just don't see this bill making it out of committee. So like I said, I'm not going to really get into the particulars here to save time. But there's some important takeaways from this bill and others that I'll address later. So next slide. So the other bill I want to touch on is the Freedom to Compete Act. Next slide. This was introduced in July. It also has bipartisan support. The act would seek to curtail the use of non-compete covenants in employment agreements for most non-exempt employees by amending the Fair Labor Standards Act. It essentially puts the enforcement into the hands of the Department of Labor in addition to a private right of action. Next slide. And again, I'm going to skip through the particulars here as well. You'll have access, obviously, to the copies of the slides. But the important thing to note here is that while it's much narrower than the Workforce Mobility Act, this bill is also likely a long shot. Similar bills in the past have been shot down. The problem with these bills and all the ones in the past that have never really made it out of committee is that they simply don't take into account the vital role that non-competes, well-drafted non-competes, I should say, and reasonable ones have across a broad spectrum of industries in protecting a company's legitimate business interests, to protect against irreparable loss of trade secrets, particularly in this day and age when many businesses now employ remote workforce or operate nationally. And so, there's just too many unintended consequences or potential unintended consequences that could lead to increase business vulnerability through the passage of these acts. And so, we're monitoring these bills, but, our understanding is that, there's probably going to be a lot of heavy lobbying, to the extent they gain any traction. But again, like I said, the important takeaways about both the Workforce Mobility Act and the Freedom to Compete Act are that, one, both bills represent a rising tide toward the desire for a uniform federal policy limiting the use of non-compete agreements. The bills all have bipartisan support. Given that non-competes arguably encroach on individual freedoms, there's popular support among both liberal and conservative circles to legislate against or regulate non-competes. And what used to be seen as somewhat of a conservative versus liberal issue is now blurred over time. The third takeaway is that these bills would also put enforcement in the hands of federal agencies, such as the Federal Trade Commission, the Department of Labor, which I just mentioned, and the Department of Justice, to monitor and even criminalize the use of non-compete agreements by employers. And we're actually seeing that happening right now. And I'm going to give you some specific examples later. Next slide. So next up is President Biden's executive order. Next slide. It was issued on July 9th, 2021 with the goal of promoting competition in the American economy. Next slide. So importantly, the order represents this shift that I was just talking about towards empowering federal agencies, in this particular instance, the Federal Trade Commission, to curtail the unfair use of non-compete clauses and other clauses or agreements that may unfairly limit worker mobility. The directive does not currently have any immediate impact on restrictive covenant enforcement, but the executive order reflects Biden's agenda about curtailing what his administration views as abusive practices. Next slide. Yep, and that's actually the first bullet point there. Like I said, there's a clear agenda from the Biden administration to curtail what his administration viewed as abusive practices. And in fact, during his campaign, he pledged that he would work with Congress to ban non-compete agreements, although it appears that he has since taken a slightly softer stance on that issue. Next slide. His agenda is pretty clear. In fact, there's currently a lot of scrutiny around no-poaching agreements in particular. The executive order encourages the Attorney General and the Federal Trade Commission to consider revising the antitrust guidance for human resource professionals issued in October 2016. And in this guidance, the government flagged the anti-competitive risks associated with wage fixing and no-poaching agreements between competitors unless it is related to a legitimate collaboration or other agreement. And we're actually seeing this happening. Last year, the Antitrust Division of the Department of Justice obtained a 2-count indictment against a healthcare company and a related entity for agreeing not to solicit senior-level employees. This indictment is the first criminal antitrust indictment for a no-poaching agreement among employers. And as you'll hear more about later, there was actually another indictment that was literally just handed down in December in the aerospace industry against Pratt & Whitney and others. I'll touch on that later as well. Next slide. So this agenda about curtailing the use of non-competition agreements is further being pushed by the Department of Justice and the Federal Trade Commission, as reflected during the DOJ and FTC Virtual Public Workshop that took place last month. And this is sort of where I want to get into a little more detail. Because it's sure to be a hot topic for 2022. So the workshop, which is entitled Making Competition Work, Promoting Competition in Labor Markets, was a virtual workshop that brought together a wide range of academics, lawyers, economists, policy experts, labor leaders, etc. Essentially, it was a think tank that was put together to discuss efforts to promote competitive labor markets and worker mobility through the lens of antitrust policies. So panelists were invited to discuss potential steps antitrust enforcers can take to better target enforcement resources and pursuing a government approach to ensuring fair competition for workers and consumers through interagency resources. And one of the things to keep in mind, in our view, is that the workshop, it wasn't just a theoretical or academic get-together. There was a real palpable desire, in our view, to put these policy objectives about curtailing non-compete agreements into action through the FTC and DOJ, including scrutinizing and limiting use of restrictive covenants at the federal level, under the belief that such policies, would encourage competition and workforce mobility. Next slide. So here are some of the topics that were covered. As you see, they cover a wide range of antitrust issues, including labor monopsony, increased use of restrictive covenants and labor agreements, information sharing among competing employers, role of other federal agencies in ensuring fair competition in labor markets, and the relationship between antitrust law and collective bargaining efforts in a quote-unquote gig economy. And there was a real sense coming out of the workshop that the overall theme was that restrictive covenants stifle competition and labor mobility. Comments were made during the workshop that suggested a pretty hostile view of non-compete agreements. In particular, that non-competes are used indiscriminately among low-wage workers, and that they're always presented as a take it or leave it type of adhesive agreement. So there seemed to be like a real visceral reaction in particular on this point following the Jimmy John's cases, which involved non-compete agreements that were imposed upon minimum wage workers. So in short, there was a real sense coming out of the workshop that non-competes are per se harmful. I think some of those comments were made, and that lifting those non-competes would somehow promote a more competitive labor market. Next slide, please. But the objectives of the workshop were not without criticism. You'll see some comments here from the U.S. Chamber of Commerce. But before I get to that, I also want to note, and it's not on our slide here, but on December 20th, 2021, over 70 attorneys and practitioners who regularly practice trade secret and non-compete cases addressed a letter to the FTC recommending against federal legislation against non-competes. A copy of that letter is actually available on our trade secrets blog that Mike just highlighted. But I just want to kind of go over some of the main points of that letter to kind of let you know what a lot of the practitioners' views are, as a result of what came out of the workshop. So one of the things that the letter highlighted is gaps in the FTC's research, which included research supporting the position that non-competes may actually help rather than stifle startups. The letter recites the fact that workers are leaving jobs in record numbers, which seems to go against the notion that non-competes stop workers from leaving their jobs. And it references studies that show that individuals subject to non-competes tend to have higher wages than people similarly not bound. And the letter, while the letter acknowledged that some of the criticisms against unreasonable use of non-competes are certainly fair, and that some regulation is evidently necessary against the indiscriminate use of non-competes, and we see that in litigation all the time. It nevertheless cited a lot of studies showing that non-competes, when used properly, actually boost and help promote the country's economy. So it's difficult to ascertain, whether or not the Federal Trade Commission or the Department of Justice took any of these considerations into account. But essentially what the FTC and DOJ at least appear to not have addressed is that, there are obviously circumstances where reasonable non-compete agreements in specific circumstances, can be necessary or are necessary to protect an employer's legitimate business interests, including trade secrets, confidential information of clients from being misused, as long as customer goodwill, which is why we have these agreements in the first place and why they are recognized and enforceable in most jurisdictions throughout the country. And this same sentiment was similarly expressed by the U.S. Chamber of Commerce. The same day as the workshop, the U.S. Chamber of Commerce submitted comments to the FTC expressly stating that when used transparently and appropriately, non-compete agreements can benefit employers and employees alike. And here on this slide, there's a snippet from that submission. And within that article, the U.S. Chamber of Commerce posed the question, do reasonable non-compete agreements stifle competition? Answer, no. Reasonable non-compete agreements protect an employer's unique and competitive information, which includes employee training, trade secrets, client lists, from being used against the employer to unfairly advance the interest of a competitor or new business. And the same article further states, considering the worker shortage and the need for properly skilled talent, non-compete agreements are a way for employers to signal the value of an employee to the organization and the key role that employee plays in the business's performance. So the point of all this is that there's significant disagreement regarding the efficacy of non-compete agreements as it relates to its impact on competition and workforce mobility. But obviously the agenda of the Biden administration, the FTC, the DOJ, and other agencies are clear in having the belief that these covenants stifle workforce mobility and competition. So we're going to see a lot of how these policy issues are going to play out in 2022. including a much more active FTC and DOJ, which leads me to my last topic. Next slide. Criminal prosecution against no-poach agreements. Next slide, please. Yeah, so earlier we discussed the indictment obtained by the DOJ against a healthcare company for agreeing not to poach senior level employees. But more recently, on December 15th, 2021, federal prosecutors obtained a criminal indictment against 6 executives, so we're talking about individuals here, of Pratt & Whitney and other engineering suppliers for conspiring to refrain from soliciting or hiring each other's workers. And these no-poach agreements right now are obviously being heavily scrutinized by these federal agencies because they're viewed from an antitrust perspective as, a form of wage suppression and also, anti-competitive. So from a wage suppression standpoint, this has spilled over into civil class action lawsuits. One was just filed a couple weeks ago in Connecticut federal court brought by employees alleging that the conspiracy impacted their wages and careers or have been otherwise harmed by defendants' alleged unlawful no-poach agreements. And, we think this is just the start of what will likely be a ripple of additional lawsuits on this point going forward. One other thing to keep in mind is that while the indictments right now appear aimed at collusion on a wage suppression standpoint in specific industries, from a practice perspective, this presents a cautionary tale for, parties to a litigation who seek to sometimes add no hire provisions when they try to settle cases with, the competitive adversaries in situations where maybe employees move from one business to another. Oftentimes, as part of a settlement, there may be an agreement, hey, we'll stop going after each other's employees. Well, this is going to be a problem going forward. And the safest bet at this point would probably be to avoid such clauses entirely so as not to run afoul of any allegations of collusion or any antitrust laws. So, obviously we'll be continuing to monitoring this going into 2022, but we expect that this is going to be, a hot topic. So next slide, please. So now I think we're going to turn it over to trade secrets. I'm going to hand it over to Robert.
Thanks, James, and thanks for joining us today. I'd like to give you the CLE code. The CLE code is SS1823. So that's SS1823. Now we're going to change gears a little bit and start talking about trade secrets and do sort of a recap on the Defend Trade Secrets Act 5 years later. Now, of course, the law was passed in 2016, federal legislation providing companies a property right under the federal law in trade secrets. Prior to that time, trade secrets had solely been, in general, the province of state law. Next slide, please. And so as we do a retrospect of, where are we at now after the passage of the law, one of the Lex Machina has done a report on, trade secret litigation under the DTSA. And what they found is that obviously there's been an uptick in the amount of claims brought under the Defend Trade Secrets Act from a period of time in, prior to 2016, where it was the province of state law. They've seen approximately a 70% increase in the number of trade secret lawsuits in which a DTSA, Defend Trade Secret Act claim is brought. And that obviously provides with jurisdiction in federal court. So we're seeing more cases being brought in federal court as opposed to state court. Now, as far as, where are these cases going, they were able to do a survey of the cases that were filed across the country, and they found that 67% of the cases were resolved by way of settlement, and 16% of the cases were resolved on procedural grounds. On the merits of the case, claimants or plaintiffs are 4 times more likely to prevail at trial, while the defendants are more likely to prevail on summary judgment or judgment on the pleading. And as far as the cases where the defendants were successful, what they found is In 114 cases, the courts found a failure to identify the trade secret such that a claim could go forward. And in 63 cases, they found a failure to maintain secrecy as fatal to the plaintiff's claim. And we are seeing an uptick in the amount of damages awarded. I looked up the most recent version of the report, and what we saw is an increase in 2019. Trade secret damages across the country was approximately 98 million. And for 2020, we had $591 million in trade secret damages awarded. So I think one key takeaway as far as this report goes is where do plaintiffs go wrong? Where they go wrong is where they are not able to articulate what the trade secret is. That can often be fatal to the case as reflected in the report. And then the other area where they're, from a high level perspective, where they can go astray is where they're trying to protect information where they haven't done a good job of maintaining the secrecy of the information, and that can be fatal to the claim as well. Next slide, please. And so in surveying, the latest developments, from 2020 and 2021, we took sort of a thematic approach of high-level issues that we've noticed and that are often significant in trade secret cases. And the first topic has to do with the sufficiency of the pleading. So when you actually bring your lawsuit for trade secret and misappropriation, what you put in your complaint and whether it's going to be sufficient to withstand a motion to dismiss. And what is significant here, though, is that in this particular Third Circuit decision, it's a similar scenario that you see in these types of cases where you have an employee leave and join, what may be a competitor, and what is sufficient to allow the case to move forward and get access to discovery where you have suspicions that something is amiss, where you believe there is circumstantial evidence of trade secret misappropriation, but you may not know exactly the specifics of, what specific file was taken and what are all the wrongful acts that occurred. In this case, in Oakwood Labs, is a positive case for the plaintiff's bar in trade secret cases because the court rejected very, very strict trade secret identification pleading allegations that would be required to maintain a claim. The court rejected what the district court had done and found a more lenient standard in assessing the plausibility of a claim. So let's go into that case a little bit, and I think it'll help elucidate why this really is a significant case. Again, coming from the Third Circuit, the plaintiff alleged that a former employee that developed products that were substantially similar and competitive with the plaintiff's products using the plaintiff's trade secret. And on the motion to dismiss, the defendants really attacked the adequacy of the pleading and basically indicated that there's no way of knowing what are these secrets that were alleged to have been misappropriated. The district court adopted that reasoning and said, yeah, there's just not enough specificity here about what exactly occurred with respect to the specific trade secret. And the way the Third Circuit articulated is that what the defendants had done is try to blend together an identification of a trade secret element and the misappropriation element, when in fact only discovery will reveal exactly what the defendants are up to. And the court held that the plaintiff had described its trade secrets with sufficient particularity to separate it from matters of general knowledge in the trade secret or in the trade, or of specialized knowledge of those persons who are skilled in the trade to permit the defendant to ascertain at least the boundaries within which the secret lies. And that's significant because that's one of the the key things that you have to do when you're asserting your trade secret claim and drafting your complaint is really identifying how this is different from general knowledge or specialized knowledge of those that are skilled in the trade. And the other key takeaway is that the Third Circuit rejected the district court's reasoning that you needed to allege that you needed to allege copying, that the copying was the necessary allegation in order to satisfy the use requirement under the DTSA. Next slide, please. The court said that it's not, we're not going to, it's going to be a more malleable standard, and that you can allege use by looking at all the different ways one can take advantage of the trade secret information. And it doesn't, things such as competitive advantage, other commercial value, or being able to accomplish a similar exploitative purpose, such as assisting or accelerating research or development. The court put in some very helpful language as far as what is sufficient to allege circumstantial evidence of misappropriation. And in this particular case, the court pointed to the timing of the employee's hire by the defendant, deception in the employee's departure, the corporate defendant's lack of experience in the industry, the low financial investment made by the defendant, and the quick success of the defendant. And the court found that the plaintiff's complaint was sufficient to raise a right to relief above the speculative level on the assumption that the allegations in the complaint are true. So this is a very favorable decision for the plaintiff's bar in these similar type factual scenarios where somebody goes to a competitor and you have beliefs that they're misusing your trade secret. Next slide, please. I'd like to go to the next slide, please.
Hold on, Robert, let me. Go ahead, Robert.
Okay, so the Third Circuit case is in contrast to a case that we saw out of New York, which is a little bit more favorable to the defendant's bar. This particular case, there was just evidence that the employee retained the former employer's data, and there wasn't more allegations with respect to actual misappropriation or threatened misappropriation. And the court indicated that since there was not sufficient allegations showing that the employee was actually using that information and exploiting that information, that wasn't sufficient at the pleading stage to maintain a claim for trade secret misappropriation. Next slide, please. Another key issue that comes up, and it was sort of brought up in the Third Circuit case that we discussed, one key issue that comes up repeatedly in the trade secret cases is whether or not the trade secret has been identified with sufficient particularity. Now, there are some states, including California, that have an express requirement that you identify the trade secret with particularity. And that's not, that often is a state requirement. That's not necessarily a requirement under the DTSA, the federal statute. But what you're seeing is more and more a push by holding plaintiffs to a high standard of identifying that trade secret before discovery can commence. And I think you see a lot of that in this new decision that came out of the Third Circuit in the Mallet case. And in that particular case, a preliminary injunction had been issued by the district court, and the Third Circuit found that the identification of trade secrets justifying that preliminary injunction order was insufficient, and ended up vacating the injunction order. What the court said was that there was no basis to uphold the decision granting injunctive relief since its irreparable harm determination appears to be dependent entirely on the defendant's misappropriation of the plaintiff's trade secret. And the court said the bottom line is this: without knowing what particular information the plaintiff claims as trade secret, we cannot accept the likelihood of success in establishing the information that the defendants acquired, disclosed, or used is trade secret information or that misappropriation of a trade secret had occurred. So you're seeing more courts having exacting standards, at least on appeal, of having an understanding of what the trade secret is that was misappropriated, and generalized labels are not going to cut it, at least in the Third Circuit. Next slide, please. Also see thoughts of significant cases on the reasonable secrecy issue that's necessary to establish trade secrets under the DTSA or the state law trade secret statute. In one particular case in California, the MBS engineering case, the court thought it was premature. There was allegations by the defendant, and this is in the marijuana space, that the particular trade secret could be easily reverse engineered. And the court found that was premature to make that argument that it could be reverse engineered, that's more of an issue of a question of fact on summary judgment or trial. I also wanted to highlight the EMC case that also deals with reasonable secrecy efforts. And there, the district court held that the plaintiff could not state a claim for misappropriation where the non-disclosure provision was only applicable if post-employment after resignation. And I think that's a clear mistake as far as the drafting of the non-disclosure, and it's an indication of the courts really scrutinizing what the non-disclosure obligations are and not doing the employer any favors if they draft an agreement that's unintelligible and really holding them to the letter of their agreement. The same thing in a significant case coming out of the Ninth Circuit, the Blade Room case, in which the Ninth Circuit reversed a $60 million verdict on the grounds that the district court should not have ignored the plain language in the NDA, providing that the confidentiality obligations would terminate after 2 years. Next slide, please. What we're also seeing as a trend is really exacting compliance with any sort of sealing obligations under state procedural and federal procedural law, even though the DTSA and very many state statutes allow the courts to treat trade secret cases differently and allow them to grant sealing requests as necessary to protect the trade secret. It makes sense, right? Because the trade secret case, the information is alleged trade secret, so that there should be a softening of the standards in order to pursue that case in the courts. But what we're seeing is no special treatment for trade secret cases. If you want things out of the public's view, and if you want things sealed, the courts are really holding the plaintiff to the state procedural requirements to establish the sealing of particular information. The viewpoint being that information should be available to the public, and even though you're asserting a trade secret case, we're not going to make any special exceptions for you. So people that are bringing trade secret claims, you really need to take that into account from a budgeting perspective, because you may think that you'd just be able to file your complaint, do some discovery, but some of these sealing motions could be quite expensive and very exacting. Next slide, please. Touched on this a little bit about when you're making your allegations and pursuing your case, you really need to show that the information that you're claiming as trade secret is not generalized knowledge and is not information that's readily ascertainable. And as you can see on the slide, we had two cases where the court found that the showing was not sufficient, and that that the argument was that the argument had merit, that the particular information that they were trying to protect was decades of know-how and experience that the employee had. Also, in the Vida case, the court indicated that this information was out in the prior art, that it was not trade secret, and it was readily ascertainable by looking at various patent filings. Next slide, please. Another hot button issue in trade secret litigation is the typical customer list case, And what we saw is a little bit of a contrast. California, which is a notorious jurisdiction, making it difficult for plaintiffs to maintain trade secret case, actually have a customer list where the court found that non-public, personal cell phone numbers could be protectable as a trade secret. It had to deal with the high-polluting technology of a nail salon, nail studio. So a little bit of a surprise that the court found that type of customer list information was protectable. But I think the facts in that case were pretty egregious as far as data theft went. But in Oregon, in contrast, the court found that basic customer information such as customer identities and email address, without more, does not give rise to a trade secret claim. So the court's really wanting to show if that information, customer identity and email address, how is that information treated within the industry? How do you protect that information? Is it publicly accessible? So really stricting the requirements if you want to make a customer list type claim, at least in Oregon. Next slide, please. As I indicated, the amount of damages for the plaintiff in 2020 was quite significant in trade secret cases. As part of that Lex Machina report, $591 million. Here's an example of some cases we saw in 2021, $8.5 million in a case down in Texas. And then also we had a pretty significant case in the Northern District of California, $14 million were awarded. So we are seeing some large either bench trials or jury verdicts issued. Next case, next slide, please. One of the big risks to plaintiffs that bring trade secret cases is fee shifting, and if there is evidence that the case was not brought in good faith, that fees can be awarded, and that that you can get into those cases where those types of situations where the information is publicly available, that you disclose the information that you claim to be a trade secret willy-nilly. You turn it over to your customers without any confidentiality obligations. And so that's why, a good investigation, pre-filing investigation is necessary to really understand the information that you're claiming as a trade secret, so that you can sort of pressure test it to make sure that it holds up, because there can be significant consequences if you bring a claim that's later, deemed to be brought in bad faith. You thought you were aggrieved, you thought you were going to get an injunction, and you end up having to pay the defendant's fees. So that's going to be the real risk. And there was a significant case that came up in Illinois in 2020 in that regard. Next slide, please. We had a significant decision coming out of the U.S. Supreme Court dealing with the Computer Fraud and Abuse Act. The issue there being if an employee has access to a customer database as part of their job duties, but they use that customer database or they use that database for an improper purpose, is that a violation of the Computer Fraud and Abuse Act under the exceeds authorized access? And what the Supreme Court did there is they resoundingly said no. They basically said that if you have access to the sensitive electronic information and you use that information for an improper purpose, that's not going to be a violation of the Computer Fraud and Abuse Act. There's a little bit of uncertainty left in wake of the court's decision. The court didn't answer the question about what happens when the individual's authority to access the information within the system is governed by a policy, and if they violate that particular policy, can you still bring a claim for under the CFAA, or is it only when they contravene a technology restriction that the CFAA can be actionable? So it answered some questions, but it opened up a lot more questions about whether contract policies can still regulate access. Next slide, please. And then I think finally, to conclude, we wanted to provide some high-level drafting considerations and practical pointers. I know that we're sort of at the witching hour. We've heard a lot about the Great Resignation. We're seeing more and more employee mobility. We're seeing issues coming up with respect to non-disclosure agreements, non-compete agreements, whether those are enforceable, what happens, should you be revising your employment policies in light of the Van Buren case? How can companies do a better job of protecting their trade secrets? Next slide, please. As we see more and more companies going to a mobile workforce, and we have people working different locations across the country, the HR and labor and employment attorneys, they really need to get a handle on where their employees are at, what their employees are doing. Do they have NDA agreements with those employees? Have their technology policies, been updated? Have they provided effective training to employees that are working remotely about, where they're storing their data? Do they have the ability to store data on personal computers, personal USB devices? And then, if you're asking those employees to sign restrictive covenants, where are those employees located? Do the state laws prohibit those types of covenants? What about choice of law? What about, forum? And so those are all real considerations, particularly when you're seeing lots of government scrutiny on particular covenants. And then from the non-disclosure perspective, has your company really identified what it believes to be its trade secret in its NDA, or did it just pick up a form off the internet and not do a lot of thoughtful reasoning about what it is trying to protect and how it's protecting that type of information? So those are all things as you move into 2022 as far as a good hygiene, as far as your policies and procedures. Dust those off, take a look at them, start making these critical inquiries, and trying to improve your agreement and sort of fair play with your employees. With that, I'd like to thank you for joining us for this kickoff question, quick kickoff webinar. There's been reference, next slide, there's been reference to our web or our blog. You can find it at tradesecretslaw.com. We try to follow the more significant trade secret cases across the country. We also try to alert you to developments in restrictive covenant law. And those that are longtime followers of our group, you also are aware of our 50-state desktop reference that's available as well. So I'd like to thank you for your time. For those that have asked questions, we can follow up with you individually. We have a record of those that have asked questions, and we will do so. And if you do have any questions, feel free to reach out to the panel, Michael Wexler, James Yu, myself. Thank you for your time. Have a pleasant rest of the day. Thank you.